It's another video, and in this particular video we are going to be talking about acceptance. So remember, the last time we ended offer in contract law with Nana Domson, and in this video we are going to be talking about acceptance. Okay, so someone has made an offer to you. How do you communicate your acceptance to it? Okay, so if you is it that when someone your oral acceptance is not enough, you have to put it in writing just because the person wrote to you or offered whatever it is that he offered to you by letter? That's what we are going to look at. And acceptance is quite a short area of law, so we are going to this video is going to be quite a short one, I promise. But just as a way of starting, let me say that if you have not subscribed to our channel, please do so. And if you haven't been commenting, kindly comment, because that's the only way we get to know what you think about our videos, and that's the only way we know what you want from us, what you want to know about the law. Okay, so just once again, as a way of reminder, School's Law is merely for educative purposes. We do not profess to be lawyers, and we are not holding ourselves out as lawyers. So if you want legal advice, you're in the wrong place. If you want legal advice, you would have to contact qualified lawyers. Okay, now straight to acceptance. Acceptance in contract law is no different from acceptance in English. Okay, acceptance simply means accepting an offer. Okay, when someone makes an offer to you, when you assent to it. However, that is acceptance. But then it is very important for your assent to the person's offer to be unqualified. Okay, there shouldn't be any conditions attached to your acceptance. So for example, I offer to sell you a shoe at 300 cedis, and you say that that's my offer. Okay, and then you respond to this offer by saying that you only buy the shoe at 2,800 cedis. We know that this is a counter offer. Okay, and so it brings an end to my offer. Just like that, my offer to you to sell the shoe at 3,000 cedis comes to an end when you qualify your acceptance. In that instance, you cannot say that you have accepted my offer. And a very good case, or a very good example, is the case of Degbe versus Insia. And we've done this case in our previous video somewhere, but then just as a way of recap, let me say that Degbe versus Insia was a case where the plaintiff actually he had this agreement with the defendant, who was his landlord, that he was going to buy the house that he was in. So the house had already been rented out to him, only that this time around he no longer wants to stay in it as a tenant. He wants to buy the house. So the landlord wrote to him, giving him a specific price for the house, but then he said that he would be glad if the landlord reduced it to another amount. Okay, now the landlord went ahead to sell the house to someone else, and this plaintiff came to court saying that we already had an agreement. It's not that I said I wasn't going to buy the house. I'll buy the house, only that I want you to reduce it small. But then the court held that, or the judgment had been that, you see, when he wrote back and asked for a reduction, he had qualified his acceptance. And when you qualify your acceptance, when you give a certain condition attached to your acceptance, it no longer operates as an effective acceptance. It is no longer acceptance. Okay, so it has to be unqualified, right? Now, mental acceptance cannot be acceptance. Someone offers to sell you a house, and then you say that I've accepted this thing in my head, so we have an agreement. No, acceptance has to be communicated. Okay, and it has to be communicated. Maybe if there's a particular way both parties had agreed for acceptance to be communicated, then you stuck to it. But if the parties had not agreed on a particular mode of acceptance, then the mode of acceptance will be determined by the given circumstances. Okay, right? So whatever it is, the acceptance has to be communicated to the offeror, has to be communicated to the promisor before we can say that it is valid. Okay, so there is a case of Forfait versus Zanyo. Now, in this case too, the plaintiff was a tenant in the house of the defendant, and now they wanted to sell the house to him. Okay, so they wrote to him telling him that they want expressing their interest to sell the house to him, right? The long and short of it is that he did not respond to the letter, and he kept on paying to them, right? And they also took it that he was only paying his rent to them and not the purchase price of the house. Okay, now after he had paid a specific amount, which he thought was the purchase price, They refused to transfer the house to him. So he brought the issue to court, and the court held that, you see, the defendants wrote to him, or they communicated their offer to him by letter. It only makes sense that his response could have been through the same means, okay? By not responding to the letter, by not doing anything to signify to the offeror that he had accepted the offer, there was no contract of sale that had been concluded. Okay, so it is important that acceptance be communicated. When someone makes an offer to you to sell something to you, you must, by your conduct, by writing, or by oral means, communicate your acceptance to the offeror. Otherwise, there is no binding contract, and you cannot come back later and say that the person did not and you cannot come back later and fault the person. The last thing we'll be looking at in terms of acceptance is the postal rule, okay, which was developed in the case of Adam versus Lintel. Now, in this rule is simply that when you post your acceptance, okay, so if your letter, your acceptance was supposed to be communicated by letter, okay, and you send it to the post, the acceptance is deemed to have been communicated on the day that you sent the letter to the post, not the day it was received. So if you send the letter to the post, and by virtue of whatever means, the letter never gets to the offeror, you are deemed to have validly accepted the letter. But obviously, in this day and age, do you think that rule is still relevant? Because these days there are faster means. A lot of people would communicate via WhatsApp, they will communicate Instagram, Messenger, email, all of these, in phone calls. So perhaps this rule is a bit outmoded, but then many years ago, after the time it was developed, it was very crucial because the post was a means a lot of people used to communicate. So these are a few things to note about acceptance. Just bear in mind that acceptance under the law of contract does not have to be qualified. Once you qualify it, as we explained in our previous video, then you may be finding yourself entering into what we call counter offer, which may actually invalidate the entire argument you are trying to make. So this is where we end today's video. As I've said, if you have not subscribed to our YouTube channel yet, please subscribe. And our YouTube channel is mainly for educative purposes, not for, you cannot rely on it as legal advice. This is where we end. Thank you very much for staying with me. Like, comment, share. If you haven't subscribed, subscribe. Bye.